Well, as you can see, that's the first item on our agenda this morning, the Supreme Court on Imo judgment appeal. And of course, this came after the Supreme Court's judgment on Bayelsa. And of course, you know, what has happened as a result of that one. The Supreme Court held that the application lacked merit and decisions of the court are final. That's for the Bayelsa elections. They also said the applicants failed to point out errors, stating that the judgment is final for all ages and the application constitutes a gross abuse of judicial process. The judgment is final in the real sense and no court on earth can review the judgment. The applications are frivolous and vexatious, and the Supreme Court awarded the cost of 10 million naira each against the applicants to be paid by their counsel. That really is something.
Yeah, and if you now look at the Imo results that we had, the judgment we had yesterday, I should say, it was quite different. The tone of the judgment was quite different from what we had with Bayelsa. You hear Justice Ariwola, who delivered the judgment, saying that there is no constitutional provision empowering the apex courts to sit on appeal over its own judgment, going on to rule that the court does not have the competence to review its own judgment. You can see that the language is quite different. Now, according to Justice Ariwola, the finality of the Supreme Court is entrenched in the Constitution, so the inherent powers of the court does not allow it to review or set aside its own judgment. As you may have heard, the justices of the Supreme Court ruled 6-1 in dismissing the appeal. And there's been a lot of talk about that single one, Justice Oweze, who dissented. But those are some of the things we'll discuss this morning.
Yes, and to hold that conversation with us this morning, we have Professor Akin Oyebode. He's a professor of law and jurisprudence. Thank you so much, Prof, for joining us this morning. It'll be good to, first of all, to have what's your own take on the judgment of the Supreme Court, especially on the recent Imo judgment, you know, the one that held yesterday.
Well, for me, it's an affirmation of the maxim res judicata. Lawyers, especially those who went through the full curriculum, from legal methods to legal system, and finally to jurisprudence and legal theory, should know that maxim very well. A decided case, especially by the highest court in the land, warrants no re-litigation. We can't continue to litigate a matter ad nauseam. In other words, the Supreme Court upheld the tradition in America, I'm talking of American jurisprudence, the Reality School especially, as articulated by people like Felix Frankfurter and others, to the effect that when a court decides a matter, that is the end of the discussion. I quite appreciate the dissenting opinion of Justice Oweze, but then that's just one judge out of 7. So the majority division, 6-1, did not feel inclined to reopening the issue. And that settles the matter. That's my first take on this issue.
Well, it would also, I mean, you referenced the dissenting judgment, and that's, to some people, would also speak volumes. Do you see any merit in some of the arguments in the dissenting judgment?
Well, dissenting judgment is not altogether new in our experience. I recall the case of Awolowo and Shagari and Fedeko, where Justice Kaldiesho stood alone not to accept the 12 2/3 rule as propounded by the majority. It just has historical effect. So you can reference a dissenting judgment to what happens and the perception of a particular judge. But that is to say that on the case. Justice Owens is an accomplished jurist. By the way, he holds a PhD, and he's well respected in legal circles. But in this case, he's alone. It would have been more dramatic if we had a 4-3 situation. The 6-1 is a rounding majority decision. I feel that the Supreme Court could not upturn its position, especially coming soon after the Bayelsa case. I think the lesson of all this is that litigants should learn to accept the tone of finality which the Supreme Court adopts in order to put an end to litigation. Definitely not everybody will be satisfied by the majority opinion, but as far as the law is concerned, that majority opinion is the law today.
Now, do you think that the fact that this particular judgment came right after, the Bayelsa judgment, where the court says, we are final, and that is final, do you think the fact that it came right after also perhaps affected this judgment? Because it would seem as though the court is not consistent if it once said we're final, and then for this judgment it says, okay, fine, let's review the judgment. So do you think that played a role maybe in the decision of the Supreme Court yesterday?
Well, as far as I can see, and as I said, bearing in mind the American experience, okay, it will be completely inconceivable for the U.S. Supreme Court to backtrack on its decision within just 2 weeks. Of course, I agree with Justice Nweze that the role of the Supreme Court is to do justice, so that it has an inherent jurisdiction to ensure that justice is done. But as far as the matters go, the Supreme Court was not inclined to reopen the issues, to retry the case. It has made its decision already regarding the merits of the application. And it will have been hoping against hope, asking for the impossible, expect the Supreme Court to go back on its word. I think the similarity of the Bayelsa case and the Imo case is there, even though it might be tenuous. The fact is, the principle that the Supreme Court, in my view, wants to affirm and uphold is that it will not go back on its decision except and unless there are new facts or there are clerical errors and what have you. We all know that once the Supreme Court decides the matter, the only court of appeal left to go to is that of God. So I think we should just look with equanimity at the decision of the Supreme Court. Otherwise, there will be no end to court cases. And I believe the Supreme Court is imposing damages for the frivolity of the application, asking it to enter into a somersault, I think, to discourage other prospective litigants who might want to relitigate matters that are already decided. As I said, it's victory for res judicata.
It would seem time and again from the statements we have heard that the goal is usually to reach an end, to reach a finality. And some will ask, so what happens to ensuring that justice is served? So if you were to give both of these things, weight, which will carry more weight, reaching an end or doing justice?
Unfortunately, I'm losing some of your comments, but the courts usually strike balances between law and justice. As a holder of a doctorate in jurisprudence, I will go with the thinking of the Supreme Court that, look, we should move on. The matter is decided. And then we should continue to live our lives. As I said, in a dispute, there will be winners and there will be losers. Okay? But the majority opinion is critical in order, as we say in Nigeria, to move the country forward. So I will join the Supreme Court in not favoring reopening the issue. Hope Uzodinma has been declared governor of Imo State, and that is the end of the story. So quite sincerely, I don't think we should belabor the issue. The appeal has been heard, won and lost. It might be uncharitable or unpleasant, a little bit untoward, to have a situation where the courts would determine who becomes elected instead of the electorate. But that is the price we have to pay for underdevelopment. I think we'll get above this. We'll surmount the present difficulty. Look at Israel. They've had 3 elections in a year, and heavens haven't fallen. Netanyahu is claiming to have won with a majority of 2 votes or 2 seats. So every jurisdiction will tell its own story. In Nigeria today, once the Supreme Court decides, that is the end of discussion.
Before we go to Maokwe in Abuja for a question for you, sir, there is also this issue of the litigants themselves who have representatives who are legal practitioners. How do you balance that out as well? Because both sides always have legal representatives, at the courts who are supposed to know some of these things that you are talking about. There is always for and against those who are supposed to know that the Supreme Court decision is final and it should be an end to litigation.
I used to tell my students that lawyers never lose cases, only litigants do. So you might say the lawyers on the loser side are somewhat disingenuous, but then they have to have their day in court. They've had their day. And as I said, non-lawyers might not appreciate legal technicalities, but the fact is, a dispute has to be resolved. And once the Supreme Court considers the ramifications, the facts, and everything involving the matter, and makes a pronouncement, that's a judicial pronouncement. As the Americans will say, lawyers have their say, but the judges will have their way. You see, law is whatever the judges declare it to be. And once the judges, because they are highly trained, they are erudite, they are exposed, are supposedly experienced, and will take into account the various nuances and dimensions. To that extent, I think it's just a bad day for the losers and the glorious day for the winners. There are no 2 ways about it. One side wins, the other side loses. And it's now a matter left for maybe academic discourse in law journals. As I said, I remember the heydays of Awolowo versus Shagari and Fedeco. I was then a columnist for a national daily, and I did a piece on that decision. But as an academic, I could, of course, interrogate the motivations of the majority. I didn't buy the arguments of the majority, but that did not remove Shagari from the presidency. The losing side will nurse its wounds, and life will go on thereafter. That is my position on this matter.
Prof, you have talked about how the Supreme Court has tried to stamp its foot, it would seem, reiterate very strongly the principle of finality. Now, when the Bielsa matter was decided and that principle was restated, people already assumed that what we might see would be a withdrawal of matters. But that did not affect the other matters that we saw, because the IMO appeal for review went on, and now we also know that a Zamfara appeal for review is also going to be held on the 14th. Shouldn't we be seeing a withdrawal of appeals for review by now, given how these two judgments have gone?
Now, I agree with you. If we were living in a society of rational human beings, here, litigants want to fight their case to the bitter end. And going by what transpired in Zamfara, in Bayelsa, it would have been my counseling to the litigants in the future to quietly withdraw their applications and cut their losses and learn useful lessons from what has transpired. Res judicata is a hallowed principle of law. I don't know why people have not discussed the matter along the lines. The lead judgments by Mariam Audi enunciated all these points, that there should be an end to litigation, because there is life tomorrow. The world will not end today. So we should be hopeful that in the future, the lapses in our system will be remedied, okay? But we won't uphold those lapses just because we want to pay lip service to formal justice. For me, as I said, we have to leave the matter to comments in law journals or even newspaper articles. As of now, the matter is already decided.
Well, we saw in the first case in Bielsa how the lawyers involved in the matter were fined. In this instance, we didn't see that. Do you think that the dissenting voice, the fact that there was a justice who dissented from the majority, watered down perhaps the inclination, if the Supreme Court had any, to want to fine lawyers?
I can just surmise what you are speaking, because the line went off towards the end of your submission. But the fact that there was one dissenting opinion should not detract from the presidential value of the majority decision. In the future, maybe as we experience in a place like the UK, Lord Denning, who usually make dissenting opinions in certain matters, to be later upheld in a subsequent case, could play out in Nigeria. That is to say, the Supreme Court can change its mind in the future and take and endorse and affirm the dissenting opinion of Oyebode. But that will be in a future matter, not at the present case. For now, the law is as the Supreme Court has found it. We have just one Supreme Court, and panels, 7 judges, that's the full court of the Supreme Court, and having carefully considered the facts, came to the conclusion that the application lacked merit. When they say your position lacks merit, we should not waste time discussing the facts again. The Supreme Court is the Supreme Court. I remember my student days, Bora Laskin, who was Supreme Court of Canada, they usually joke about him, Bora and the Supremes. You know, the Supreme, the musical group, and what have you. But on a serious matter, this is the Supreme Court. There's no other court higher than the Supreme Court in this country. And we can't really whittle the stature and standing of the Supreme Court by pontificating on the propriety of the dissenting opinion. Dissenting opinion becomes, in this circumstance, merely academic. It lacks precedential value. And except the Supreme Court decides in the future to change its mind, I'm afraid we just have to live with the majority decision.
I was wondering, Prof, if you had any opinion on why you think, because the Supreme Court was very seemed, I mean, the judges seemed pretty upset when they delivered the judgment on Bielsa, and it seemed to reflect in the fines that were imposed on the lawyers who represented the parties, especially the side that was applying for the review. In this instance, that hasn't happened. Why, in your opinion, do you think it hasn't happened?
Well, I think the Supreme Court was so hard on counsel because of the stature of the legal practitioners. Somebody like Chief Afebabaola, who is a guru in constitutional matters. I mean, somebody has been lawyer to 3 or 4 presidents of Nigeria. That is no ordinary lawyer. Then, of course, Wole Olanipekun, in election matters, you can say he wrote a book. He has been winning cases right, left, and center. The past president of the Nigerian Bar Association, and who is revered in legal practice. So the court expressed its anguish that lawyers of that caliber, of that stature, will be twitching the tails of the Supreme Court, as it were. So the lion roared back and gave them a dash on the face in order to teach others not to attempt it. Because they will pay the cost because they are really very affluent lawyers. But I think the Supreme Court was addressing lawyers of less caliber, not to dare it. And they had to pay the price on behalf of the profession. As I said earlier on, you should not lambaste lawyers if they decide to test their matters in court. It's their prerogative. The best the court can say is that your case lacks merit. But now to rub salt on their injury amounts to almost an overkill. And I think the Supreme Court went for broke by inflicting such penalty on the lawyers. Because if you block access to litigants in cases, then you are inviting self-help. You are allowing or admitting possibilities of revolution, as was opined by Fatai Williams, that if you don't let people ventilate their grievances, you'll be stirring up protests and upheaval, which might really bring the roof down on everybody. So quite sincerely, as I said at the outset of this discussion, courts have to mediate between law stricto sensu and justice. Because if you allow judges to substitute themselves for the electorate routinely, then what's the purpose of elections? So it raises serious jurisprudential problems, which I have no time to go into right now. But we have to think of the future of our democracy, the relevance or lack of it, of the ballot box, and then the consensus amongst the players, among the politicians, to play according to the rules. We have a steep learning curve for our politicians. They never want to accept defeat. They fight to the bitter end. And I think we have to gradually begin to move away from going full blast
And then
get justice.
we have to thank you very much, Professor Akin Oyebode, a professor of international law and jurisprudence. So many things to discuss because the electorate really should matter more than the courts in this matter, as you have opined. Thank you very much for your time. We're back in a moment for another issue. Please stay with us.